And welcome back. Now, residents of 11 buildings in Johannesburg's inner city are challenging the lawfulness and constitutionality of over 20 police raids which took place between June 2017 and May 2018. Now, they claim that their rights were violated as they were forced out of their homes in the middle of the night while partially clothed during the raids alleged to have been conducted by the South African Police Service, the Johannesburg Metropolitan Police Department and the Department of Home Affairs. So to get into more of this, we're joined by Khululiwe Bhengu from the Socio-Economic Rights Institute of South Africa. She's an attorney representing the residents. But I also have to just indicate that we did invite the South African Police Service to be part of this discussion, but they declined, saying that the matter is before the courts. So, Ms. Bhengu, thanks so much for coming through this morning.
Thank you, Sakina, for having me.
So first off, let's start here. You filed papers this past Monday. Tell us about the scale of this particular lawsuit, and also how many people are you representing?
So, Sakina, the papers were actually filed in May 2018. This past Monday, we had a hearing before the full bench in the South Gauteng High Court. The scale of this case, we're representing 2,852 residents of the 11 buildings, as you've mentioned earlier on, who reside in the inner city and who had been raided by the police and JMPD between the period of June 2017 to June 2018.
So what is the allegation here in terms of the lawfulness and constitutionality that you charge has been breached?
So when we inquired with the SABs as to why these raids happened warrantlessly, the response we got was that they were authorized in terms of Section 13(7) of the South African Police Services Act. And we went through the Act, and in the interest of the residents of the inner city, we realized that the Act is unconstitutional because it infringes on the right to privacy as enshrined in the Constitution, and it also, well, not the section itself, the implementation of the raids definitely infringes the rights of the residents to dignity.
But what does that mean for the actions of the law enforcement authorities? Because, as you say, they claim that they acted in accordance with Section 13(7) of the Act. So were they in breach of the Act?
So for most of the raids, they were not in breach of the Act. The Act permitted them to conduct the warrantless searches. But there's two raids that were conducted without any authorization in terms of the section.
Which raids were those, and can you explain to us what exactly was untoward about those raids?
So the first raid was the raid on the property of the first applicants, which is in Doornfontein. The authorization for that raid was supposed to happen from 8 a.m. on that day, but the raid took place at almost 3 a.m. in the morning, where people were put out in the streets and their homes were raided.
So that is the main concern here. What compensation is sought exactly by your clients that you are representing in this case?
So, Sakina, the main concern is that this section is not constitutional because it authorizes warrantless searches. In many cases, the Constitutional Court has made it clear that warrantless searches to people's home are inconsistent with Section 14 of the Constitution. So that is what we seek in this case. The compensation we're looking for two things. In the event that the court doesn't find that is inconsistent with the Constitution, we're seeking that there's a declarator that these raids will not happen without a warrant. And also, we're seeking for constitutional damages for the infringement on the constitutional rights of these residents.
And to that point, are you challenging the way in which the raids were conducted? In other words, the way in which law enforcement authorities went about their jobs?
Although that is a problem, and that is what has led us to seeking the constitutional damages, the core of our challenge is the invalidity of the section. Because, as I said earlier on, they were authorized in terms of the section to conduct those raids. But we're saying that in future, they shouldn't be authorized to conduct raids to people's homes without a warrant, and that piece of legislation is inconsistent with the Constitution.
But as things stand right now, by your own admission, they were within their rights as the law stands right now to actually conduct those raids.
Yes, yes.
So what is the problem in that regard? Because some of the people, I understand, were found not to have the correct documentation. Is that perhaps one of the reasons why the residents are pushing back, the fact that they found themselves on the wrong side of the law?
That's not the reason why the residents are pushing back. As a response, we were made to understand that these raids, these areas where these buildings are located were cutting off because there's high rates of crime. There was nothing regarding the documentation of the people. Be that as it may, we have a clear piece of legislation, that is the Immigration Act, that specifies the measures that the immigration officers need to take if they want to find people with who are undocumented. So
but is that not an act of criminality if you find yourselves in a country undocumented, because there are rules and regulations that govern how people actually come into a country?
Definitely, and that's why it's important to use the relevant piece of legislation. These raids were used to bypass, in our opinion, they were used to bypass the Immigration Act, because the Immigration Act sets out clearly what measures need to be taken when you want to find the undocumented people. And further to our argument is that even if it wasn't to find undocumented people, Section 22 of the Criminal Procedure Act already makes provision for warrantless searches of people's homes. So there was no need for them to use this particular section, especially because it's inconsistent with the Constitution.
Ms. Bhengu, how many people were arrested and what were the sort of charges that they faced subsequently?
So I don't have specific numbers of people who were arrested, but what we do know from the 11 buildings that we represent is that all the people that were arrested, they were arrested because they looked too dark to be South African. They couldn't speak maybe a certain South African language properly, and all of those people were released after, which is to show that there was no reason to believe that these people were undocumented. Quite frankly, a number of people who were arrested were South African residents with proper documentation.
So is that as a matter of fact? And if that is the case, did you lay criminal charges against the police in that regard?
That is a matter of fact. It's something we've highlighted in our funding papers in the matter. It's something we argued on Monday. The residents did not lay criminal charges in the police station. What they did to try and resolve all of this thing, they came to us as their legal representation, because we already represent them in the eviction message that they're facing. And that's when we sought answers from the provincial commissioner and took the decision to actually challenge the constitutional validity of this section.
So, as their legal representative, were there any people in those 11 buildings during those raids who were correctly arrested for criminal activity?
No, there weren't.
So nobody was arrested because there was something wrong, something unlawful that was being done in any of those buildings?
No, in the 11 buildings and the 20 raids in this specific case, no one was arrested because they'd done something wrong. And that is why all of them were released later on, because their arrests were based on prejudice.
And so what has been the response from the departments that were involved? That would be JMPD, the SAPS, and of course the Department of Home Affairs. In their responding affidavits, what are they claiming?
So the Department of Home Affairs did not oppose the matter. The South African police, under the Minister of Police, did defend the matter. And in their papers, they're saying there's nothing wrong with the section, because in terms of Section 13(1) of the Act, it does say that when reading the rest of the Act, you need to do it in accordance with the Constitution. But what we say, and which is something we've said in oral argument, is that it's not enough for us, for the police to carry the Constitution in their hearts if it's not going to be seen by our clients and the constitutional rights are still going to be infringed. What the city of Johannesburg, together with the mayor, have said in their papers is that they were there in those raids because they needed to conduct a needs assessment. So as we've said in our papers in this matter, 10 of the 11 buildings are all facing evictions, and they're all saying they'll be homeless as a result of an eviction, and they're seeking alternative accommodation from the city. One is already been provided by alternative accommodation by the city. So they have the numbers, they know who's there, because all of these people have deposed to affidavits before the court.
Well, an interesting matter that we will keep an eye on. Khululiwe Bhengu is from the Socio-Economic Rights Institute, an attorney representing residents in Johannesburg's inner city who are challenging the manner in which their homes were raided. And they are saying that they were prejudiced, they were targeted, and they have subsequently taken the matter to the courts to challenge the constitutionality and, of course, the lawfulness not only of the raids, but also of the sections that the police used within the legislation to apply those raids. Let's take a quick break.